Real people, real cases. This is Verdict Watch.
Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391, on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
I'm sorry.
Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood, and then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well, let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client you know, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order. And the order that they proposed, Your Honor, let me get specific. And because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says, it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language. Dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem because any maintenance person.
Then why don't you just ask that they can just that your client can look at it? I mean,
that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry.
If the issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property is being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water damage.
Why don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right, here's what we're going to do. I'm adjourning this to next week. Between now and next week, I'm going to order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not going to enter that order. I'm going to enter the order directing the parties to get with the county, to gain entry to the premises, That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1 little I after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.